Thank you, Torfinor. I am very happy to be with you all today at this environmentally friendly EFTA house. And I say hello to those of you who are invisible to me, but hopefully you can see and hear as well. Torfinor actually ruined my introduction because I wanted to make a joke. So my name is Melpo-Joséphidès, and I'm the Director of Legal and Executive Affairs at ESA. Not the European Space Agency, the EFTA Surveillance Authority. So today I don't promise to take you to the moon and back, but I do promise that as I walk you through the skies of the EEA agreement, you'll recognize from far some stars, the stars of the European flag, and that's because ESA resembles a lot the European Commission and works a lot like the European Commission, and very closely with it. So this morning you heard about how EEA law is made, how it becomes incorporated into the EEA agreement. What we will be talking about this afternoon is implementation, how EEA law is enforced. I will be speaking about the role of ESA and then take your questions. I will then unfortunately have to leave, but Olafur Einarsson from the EFTA court will be speaking to you about the role of the court in the EFTA pillar. So we've heard this morning already what the EEA agreement is about. You have it in a nutshell here. It's 30 countries, 450,000 people. It extends the EU internal market, the 4 freedoms, which you see at the bottom of the slide. Persons are at the center of the EEA construction. Freedom of movement for persons, goods, services, and capital. Fair competition goes with the 4 freedoms. This means that states do not grant aid that distorts competition, and that undertakings we need to have a level playing field for undertakings so that there is real competition across the EEA. Another thing that the EEA agreement does, and that is very important, is what we call the flanking policies in the jargon that nobody understands. It's policies that are very much relating to the core of what the internal market is: environmental protection, consumer protection, workers' rights. So I won't be going deeply into these areas, but it's important to know that this is the scope of the EEA agreement. And I hope we have the time, because I would like to share with you some words about some key areas of the focus of our work in the past years at ESA. The green transition, the digital economy, fundamental values, and how people are at the center of our work. So coming now to the institution ESA, the Surveillance Authority, our mandate is to monitor compliance with the EEA agreement, check that the 3 EEA EFTA countries respect the rules that are in the agreement as it is amended in a dynamic way, as we heard this morning. What is interesting to note for the legal geeks like me in the room and at home is that its role is rooted in the EEA agreement. This means that it has been agreed on the one hand by the EU and the member states, and on the other hand by the EEA EFTA countries. So having a surveillance authority is part of the deal of extending the internal market to these countries. However, the exact mandate and powers of the surveillance authority, that is something that was internal business of the EEA EFTA countries, and so the role and the establishment of the authority is to be found in an agreement that is only between the 3 EEA EFTA states. That's what we call the EFTA pillar. You've seen a newer version of this slide this morning. I will make sure I copy it for the next presentation I make. This is a bit outdated in terms of colors and fonts, but the content is the same. You see on the left-hand side the EFTA pillar, on the right-hand side the EU, and in the middle the joint institutions. So you will see that ESA sits across the European Commission in the same way that the EFTA Court sits across the Court of Justice, which means that the roles of these institutions mirror one another, the ESA with the Commission. In order to function, the EEA agreement needs the trust. Ambassador, you mentioned that earlier this morning. Trust, confidence, la confiance is key in a good functioning agreement. And it's trust in the EFTA pillar, its institutions, and in the EFTA states. So ESA's role is pivotal for that trust, and that's because we work very closely both with the EFTA states and with the European Commission. Who takes decisions at ESA? It is a college, like in the Commission, of 3 members. One from each of the EEA EFTA states. Our president is Bente Angel-Hansen. Frank Büchel is the college member from Liechtenstein, and Høgni Christiansen, the college member from Iceland. They have, of course, a portfolio with subjects that are for which they are responsible within the college, but decisions are mostly taken in a collegiate manner by the college. And there is always a very good cooperation and a very good discussions ahead of taking the decisions. So it really helps to have this good cooperation and this collegiate spirit, and it's much easier to have it in a college of 23 rather than a college of 27. Under the responsibility of college, we are an institution with only 70 staff members. This might sound like a lot, but if you compare with the 32,000 commission staff members, you see the difference. Of course, we don't do legislation, we don't devise policies at ESA, we ensure only the compliance, and the scope of the EEA agreement is a bit thinner than everything that the EU does, but I think that the proportions are interesting. So with 70 staff, we're called to monitor the implementation of the thousands of EEA acts that have been incorporated in each of the EEA EFTA states. About half of our staff are from the EEA EFTA states. I am not, and I was very nicely welcomed by everyone at ESA, and I find it great that it's an institution that also takes EU nationals that are not nationals from the EEA EFTA states, and that we can work together to achieve the EEA agreement objectives. It is actually 20 nationalities that are represented at ESA among the staff members, not 17, so we have a bit of an improvement there in terms of diversity. And we value diversity a lot, and we're very proud of our women in management, starting from our head, Bente Angel-Hansen, who is our president. So you see, we're not a large organization, but our mandate is pretty big, and we're also very proud to be an institution that looks after its staff. And I think, although I haven't been at the EFTA Secretariat, that is the impression I have also about the EFTA Secretariat. A lot of the people have left their families behind to be in Brussels, and during the COVID times, a lot of attention has been paid to maintaining the link and making sure that everyone is helped and supported. The amount of work that was carried out during the COVID times was unprecedented. The pressure on the staff members was huge. But funny enough, we had one of the greatest levels of satisfaction at work in recent times at ESA. So I think some things were done very right, and I can say that without blushing because I wasn't around, so it wasn't anything that I did. I only joined in July. And I'm very proud to have joined an institution that takes care of its staff in such a way. So like the Commission, at ESA, there are 2 directorates that deal with the substantive issues, internal market affairs and competition and state aid. They are like the Commission DGs. They look at possible infringements and they prepare college decisions. And with them, my department, the Legal and Executive Affairs department, We assist in the work in looking at whether there are infringements, investigating cases, and we provide advice on the college decisions that are in preparation. And we also do litigation. So this is the legal part of our work in the Legal and Executive Affairs Department. There is also a part of it which is Executive Affairs, and that looks more like the Secretariat General of the Commission, where we provide executive support to college for its decision making. Part of our team in LEA is also communications, the registry, and the data protection officer. Very important horizontal functions for the organization. So together, the two directorates and my department, LEA, we ensure that ESA carries out its activities in monitoring the EFTA states and ensuring that they comply with their EEA obligations. So what tools do we have at ESA to bring compliance? Because our objective is not to go and find the problems, but really accompany and help the states to come into compliance when they are not. The first thing we do is, of course, monitor the situation in the EEA states. Sometimes the legislation has a reporting obligations, which means that the ministries will have to get back to us and show what they are doing to put in place what needs to be in place to respect the rules. And we're also able to take action in case that we found that there's an infringement. So there's a whole process for that. Member states, the EEA EFTA states need to have the law in place. They need to have the right law, so it needs to be compatible, compliant with the acts that were incorporated in the agreement, and they also need to apply the law in practice. So when at ESA we look at what the states are doing, we check those three things. The infringements is a bit like the infringements in the EU pillar, but of course it is separate. In case the states do not come into compliance, then Article 31 of the agreement allows us to bring the state to court in direct actions before the EFTA court for a declaration of non-compliance. Again, this is not something that we enjoy doing. The objective is not to reach the court stage and to try to find a way to bring compliance around. Compliance is not an objective in itself. It's our role to help that, of course. But in the bigger picture, what is important is that the rights that are there for people, for businesses across the EEA, that they can be enforced in the same way in all the countries. So we're there to support that. And we have found that in most cases, our constant discussions and dialogues with the EEA EFTA states have led to a result of compliance. So at the moment, we have 212 infringements that are open, and that's cases that have not necessarily reached the court yet, but cases where we're checking the infringement and hoping to reach compliance before we go to court. So other tools to bring the compliance around is, I'll find the slide, thank you for your patience, is inspections. So ESA has the power to conduct inspections, and inspections can be inspections in states authorities, so checking that the national authorities do the health, the food safety checks on products in the right way before they reach the markets. So we're checking on the national authorities, but also inspections on private undertakings, and that's of course to enforce the competition rules, to make sure that there is no abuses of dominant position, for example. And with that, I will, there were some questions earlier today about transposition deficits and how big the backlog is. So here you have a graph that shows the situation over the years. I will not go into it, but I would invite you to have a look at ESA's website. I think it was yesterday or the day before, ESA published the Internal Market Scoreboard, again, as the Commission does, which shows how many outstanding pieces of legislation have not been transposed yet. So on this graph, you see the situation about directives, but in the scoreboard that's on the website, you'll find also the situation for regulations. When it comes to infringements, I talked about the powers to check how we do the monitoring, how we get to hear about cases. A very important source of our work is the complaints we receive. We're in contact with citizens and businesses in the EEA EFTA states who can very easily reach out to ESA and explain how they think their rights have not been respected in their state, in which case we can open a case, look it up, talk to the authorities of the state, again, hope it is solved through these discussions and dialogue. And sometimes we do stumble on a legislative problem, and we try to identify it with that state and encourage compliance. In case all of that doesn't work, then there is the threat that sometimes materializes of court proceedings. And for that, there are 3 steps before we get to the court. The first step is a letter of formal notice, where we communicate to the state where we think there has been an infringement and give them some time to respond. If the response is still not bringing compliance, then we issue a reasoned opinion, which is the last stage before getting to the court in an action, in a direct action against that state. So what I've been talking to you about now was a lot about transposition of legislation and making sure that the law becomes part of the national law of the EEA EFTA states and that it's applied and people can enforce their rights. There is an area of EEA law that is actually directly applied by ESA. The substantive rules of what the rights are and the obligations of the states are actually in the agreement. That's the field of state aid. So state aid, because it can distort competition, like in the EU, it's not recommended, should be avoided. But there are, of course, exceptions to these rules when there are good reasons for it. And such reasons can be important environmental projects supporting a region, supporting some areas of research that would not have happened without that aid. COVID times have been very interesting for ESA because we've seen an explosion of cases, of decisions where ESA has authorized states to grant state aid. We have had in 2020 52 decisions authorizing state aid. ESA also has a specific power in the field of state aid, like the Commission, in case unlawful aid has been granted. ESA can request the state that has granted the aid to get the money back, so to neutralize the effects, at least some of the effects of having distorted the competition. What is very important in this area of work is to gather all the facts, look at the exact situation, get a very clear picture, an independent view from our independent surveillance authority. And for doing that, we work very closely both with the states and with the stakeholders. Another area of our work, which comes directly from the EEA agreement and not from derived acts that are incorporated in the agreement, is the rules that ensure a fair competition and a level playing field across the EEA. So you'll know the rules about cartels and the rules around abuse of dominant market positions. So for that, ESA has very extensive powers, like the Commission, to conduct investigations and can also impose fines on undertakings if, for example, they have abused their dominant position. You might have heard the recent fine on Telenor for having a pricing strategy which had the effect of capturing the market in the Norwegian telecom sector. The case is now before the EFTA court, so I will not be commenting on it, and we're waiting for the judgment. So now you have heard a little bit how we go about things, what are our powers, and now I wanted to focus a bit on some thematic areas that were in focus for us in the past months, because they're very important for the future and how we address those challenges together and together with the EU. First, climate. And I'm very comfortable speaking about this from here, from this environmentally friendly building, and in which we share with the other institutions of the EFTA family. This building is really in the spirit of the EEA EFTA countries and conforms to some of the highest environmental standards which come from the EU and are now part of the EEA agreement. But if we move out of this building, some important pieces of work we've done for climate is to help states measure their land use to reach emission targets. We have approved the tax breaks for electric vehicles, and so we have supported a massive project in sequestering carbon in liquid form under the sea. The digital economy, very important challenges that also pushes a bit the limits of how states are operating and the limits of their taxation possibilities. So ESA intervened in a court case before the European Court of Justice in an appeal from Apple against a state aid decision of the Commission. So that was a case about the taxation by Ireland of Apple's subsidiaries. Another very important piece of work, which is again at the core of the trust that is essential in having the EU and the EEA agreement functioning, is our values, democratic institutions, and the fundamental principles of the separation of powers. And on that, ESA intervened in a case before the European Court of Justice to support the independence of the Polish judiciary. So we can actually reach the European Court of Justice and also share the perspective of the EEA on these challenges. You might want to know that we had very good news in December 2020. The European Court of Justice, there was an order from the President of the Court which reversed the past legal situation, and it is now possible for ESA to intervene not only in preliminary ruling procedures but also in direct cases of infringements from the Commission against EU member states. So even though as ESA we're not responsible for the surveillance of the EU rules, the Commission is the guardian of the EU treaties. We are guardian of the EEA EFTA pillar. In a spirit of cooperation with the Commission, we can align ourselves and bring the EEA EFTA perspective into cases that arise in the EU but also might have some relevance for the EEA EFTA pillar. So it is not ESA bringing infringements against EU member states, but it's ESA intervening in cases of infringements commission against member states before the court in Luxembourg. This is new. A part that we're very attached to at ESA is people in the EEA, not only because free movement of people has been at the center of what the EU is about, but also because it represents some of the core values of what this college stands for. So people are at the center of the enforcement of the EEA agreement, and at ESA we have paid particular attention to protecting the right of citizens, both in the case handling and when we're intervening before the courts. We look at the right of family reunification, so the right of returning nationals to bring a foreign spouse. There have been some cases at the EFTA court, Jabi, Campbell. the right to export benefits in other EEA countries. You have the NAV situation in Norway. We're also looking at the situation in Iceland. And we've also been looking at the COVID restrictions and how that affects free movement. We're in dialogue with Norway to make sure that the restrictions that are in place are proportionate to achieve the very legitimate objectives of protecting public health. There is also the rights of movement within the EEA, so beyond the 3 EEA EFTA states. And there are cases that go beyond the scope of the EEA agreement, but touch upon what the EEA agreement stands for. And for that, I'll take the example of the case of a European arrest warrant of a person protected in Iceland, an Icelandic national, who Russia wanted to have to trial there. That person was traveling to Croatia at the time, and the question was whether the protection that's granted to EU nationals also extends to EEA EFTA nationals. And if you read that case, you'll find very interesting developments about the intensity of cooperation between the EEA EFTA countries and the EU, and how close we are. So even if it's outside the scope of the agreement, because the European arrest warrant is about criminal law cooperation, not about free movement of persons in the sense of the internal market freedoms, even there, being part of the EEA family brings some additional rights to people. Before I wrap up, I wanted to share with you a little bit about our litigation work. As lawyers, we love the opportunity to try to be legally perfect and send clear messages to the judges when we're defending the cases. And that is work that we carry out in the Legal and Executive Affairs Department, of course, under the guidance of college. So again, our objective is not to go to court, even though we do have a lot of fun when we go and we win many of the cases. But when the objective is really to bring compliance, and as you saw, most of the cases are settled before we reach the court. But when we reach the court, then that's direct actions of ESA against the EEA EFTA state that has been non-compliant. We also have to come in and defend ESA decisions. So if there's an action for annulment of a decision on state aid, then we would intervene and defend the decisions taken by college. And very central to the EEA EFTA pillar is the mechanism of advisory opinions. And I'm sure that you'll hear more about it in the next half hour. Where a national court raises a question about EEA law, it can request the EEA EFTA court to answer its question on how to handle the case and how to interpret the EEA law. And there, as ESA, we intervene before the EFTA court to give our perspective. We work very closely with the Commission as well, because most of these rules are mirrored from the EU. So it's important to have a common way of defending the scope of the EEA agreement and of the obligations. At the moment, some statistics, we have 17 open court cases, 6 advisory opinions at the EFTA court, 1 preliminary ruling reference at the ECJ, 2 defenses of ESA decisions before the EFTA court, and 7 interventions at the European Court of Justice, including the 1 direct case that I mentioned earlier of a commission against a member state. We also have 1 amicus curiae presentation where where the national procedural rules allow to have our intervention. Then we sometimes take the occasion to represent our ESA's views on EEA law. So now that we've arrived at the subject of the EFTA court, I think it's a good moment for me to wrap up. I hope that apart from the reflections of the EU flag, you also spotted the stars in my eyes when I speak about EU law and EEA law. So happy to take your questions, and I will then unfortunately have to leave soon because of another meeting. We would usually take this question and answer sessions for the two of us, but this time around it is not possible, unfortunately.
Yeah, thank you so much. We understand you have to go to this important meeting starting at 2, I think. So we don't have much time for questions, but I'm sure that there are some questions from the floor first, maybe. Yes, over here.
Yes, thank you. Sorry to bother you once again. I'm Ole Johan Carlsen, trainee at the EFTA Secretariat. You said that anyone can file a complaint. Who are the typical complainants?
Complainants as diversified as the societies in the EEA EFTA countries. You have complainants that are open about it in the press and that are more visible. Others that are recurrent complainants who come to us very often, and we're used to dealing with them. And you also have a huge number of complainants who come to us just once because they've encountered a problem, and we work closely with them to see if we can help them solve it through, I wouldn't call it mediation because that's not the right way to describe it, but when we reach out to the state authorities, we sometimes find answers that are helpful. And if we happen to spot a problem there, then this gets escalated and we see if we can solve it for more than one person, for more than just the complainant. So I don't have a profile, and there is a great diversity, and all of the complaints are useful in that they make us think about what we need to be doing and what we need to accelerate in our work to deliver the benefits of the EEA agreement in the EEA EFTA states.
Thank you for a very interesting talk. I'm Ole from the Norwegian Association of Enterprises, and I'm wondering, you talked about the green transition, and do you think that there might be some instance where the exemption for state aid when it comes to promoting the green transition might distort a level playing field and the transparency for businesses? And how do you see this development coming?
That's a very central question to the future of the greening work. How do you combine the need for public funding for projects that are so huge that they wouldn't be able to be dealt with alone by the industry with the requirement to have a level playing field? So the agreement does leave some space for balancing these two. And the Commission issues guidelines with precise criteria, which we also mirror and apply in our work. It's of course legal criteria, but they reflect a specific choice that is made given the challenges. I wouldn't be able to judge these from an economic perspective. They are the best criteria, but I trust that they are the best that we have. And making sure that it's the same criteria that apply across the EEA is what is important. These things should not vary. A state should not have a competitive advantage because it either has more money available or because the rules are more lax for it. So at ESA, what we're looking at is making sure that the rules are applied throughout the EEA, and we do our part in the EEA EFTA side. But most of the thinking behind those rules comes from the Commission.
Thank you. Maybe one last question over here.
Yes, thank you. So my name is August. I am the policy trainee of the ECD in the EFTA Secretariat. And I think this is a very interesting question. I was wondering whether ESA also works with the governments of the EEA EFTA states in relation to certain projects, such as the important project of common European interest.
Absolutely. ESA is not an institution located in the EFTA house in Brussels, disconnected from the EEA EFTA states. Our headquarters are here, but the line of communications are active every day. And our colleagues in this case, it would be both IMA, the Internal Market Directorate, and the Competition and State Aid team are in contact both with the state authorities but also with the stakeholders to get a clear understanding of what is happening, what are the options, and what is allowed, and preparing the ground so that things go smoothly. So yes, the state authorities are one of the interlocutors of our colleagues in the two directorates, and we're very proud of that work as well as the work that is done with the stakeholders. It's important to have a global view of the situation on the ground and not just hear what the ministries tell us. It's a very important part of what's happening, but at ESA we are very well placed to listen also to citizens and to businesses. I think unlike bigger institutions who need to organize processes in order to hear these views, with ESA I think the communication is much more direct, and we are a very accessible institution. You'll find our phone numbers and email addresses on the website. It's not the case in other EU institutions. And the website is very clear as to how to contact and or lodge a complaint if it's about a complaint. So we're very proud for being in contact with both authorities and private stakeholders and people.
So thanks again, Melpo.
Thank you, Torfinor. Thank you all.